Attorney Crone, are you there? I know. Don't worry. Bring him in here. It's Burr Buxton. Can you hear me?
Yes, I can.
Okay. All right. I've got the plea sheet right here. I thought you were going to be here in person, so I had it ready for you to sign. But the plea says pleading count 2, improper possession of a firearm in a motor vehicle, dismiss count 1, and mandatory forfeiture of all firearms and contraband seized.
Correct.
Are you find me signing your name to that?
Yes, that's fine.
Okay.
But you have my authorization, correct?
Perfect.
Yeah. Right.
And have you gone over your rights, the defendant's rights with him?
I have not had the opportunity to do that yet.
Okay.
We can do it now.
Okay, we can put them in the week.
I'll just do it on the record. Let's
Perfect.
get going.
You can do, this is on this one.
All right, this is docket 25-23-88 FH. People of the state of Michigan versus Trevon Terrell Hopkins. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Jacob, on behalf of Trevon Hopkins, who's appearing via Zoom.
Thank you. Sir, please unmute yourself and raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. You may put your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
All right. And sir, you had enough time to talk with your attorney. I understand there's going to be a plea today. Is that correct?
I'm sorry, Yana. Can you say that again?
I understand there's going to be a plea today. Is that correct?
Yes, ma'am.
And have you had enough time to talk with your attorney about that?
I have, Yana.
And were you on probation, parole, or bond conditions on another file before another judge at the time of this event you're pleading to?
No.
Are you a U.S. citizen?
I am.
And I have your address on Buzz Aldrin in Texas. Is that still current?
That's correct.
All right, and you are employed?
I am.
All right, and what is the plea agreement on behalf of the people?
Yes, Your Honor. The defendant be pleading to an added count 2, improper possession of a firearm in or upon a motor vehicle. Upon successful plea and sentencing, count 1, carrying a concealed weapon felony charge will be dismissed. There is an agreement for forfeiture of all contraband in this matter.
Full, fair, accurate, and complete, Mr. Pearl?
Full, accurate, and complete, Your Honor, yes.
Are you waiving reading count 1?
Waive reading.
And Mr. Hopkins, is that full, fair, accurate, and complete?
That's correct, Your Honor.
All right, as to the reading of the information.
Thank you, Your Honor. People of the state of Michigan versus Trevon Terrell Hopkins, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and the location described below, the defendant, count 2, weapons, firearm, improper possession of a firearm in or upon a motor vehicle, on or about April 10th, 2025, at I-96/Hagedorn Road, Aladian Township, Ingham County, State of Michigan. The defendant did transport in or upon a motor vehicle or other self-propelled vehicle designed for land travel, an unloaded firearm which is not a pistol or revolver, to wit, an unloaded firearm, which was not a pistol. Well, I apologize, I'm not sure what, okay. Let me rephrase that, I apologize. Did transport in or upon a motor vehicle or other self-propelled vehicle designed for land travel, an unloaded firearm which was not a pistol or revolver, to wit, a firearm, while not taken down, enclosed in a case, carried in a trunk, or otherwise inaccessible from the interior of the vehicle, contrary to statute. This is a misdemeanor that is punishable up to 90 days and or $100 with mandatory forfeiture of the weapon or device per statute. And against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read?
Yes, ma'am.
So you understand count 2, improper possession of a firearm in or upon a motor vehicle is a 90-day misdemeanor, 90 days and or $100, and there'll be forfeiture of the weapon.
Yes, ma'am.
All right. And sir, you do have the right to a bench trial or jury trial. You have the right to a presumption of innocence until proven guilty beyond a reasonable doubt. You don't have to do anything at all. It is the sole burden of the people to bear that burden. If they cannot prove your guilt beyond a reasonable doubt, then the count would be dismissed. You have the right to cross-examine any witnesses brought against you, and you also have the right to decide you want to defend the action, and if you wanted any witnesses to appear, the court would order those witnesses to appear. Then the people would be able to cross-examine your witnesses. You have the right to remain silent and not do anything at trial, but you also have the right to choose to testify at trial. If you chose to testify at trial, then you would be subject to cross-examination. If you remain silent, then it could not be used against you in any way. Do you understand all of that?
I do.
All right, and you understand that by pleading today that you no longer have that presumption of innocence or the ability to provide a defense or remain silent, all of those things that we just went over. You're really giving up everything except the right to an attorney, which I understand you understand because Mr. Crone is here and has been for all of your hearings.
Yes, ma'am.
Okay, thank you. Sir, as to count 2, improper possession of a firearm in or upon a motor vehicle, how do you plead? Sir, how do you plead?
Guilty.
And sir, has anyone told you what I will do at sentencing? Has anyone told you what I will do at sentencing?
No, ma'am.
Because they couldn't, because I don't know. I don't know much about this case. When I learn more, then I'll make up my mind. Do you understand that?
Yes, ma'am.
Did anyone force, threaten, or coerce you to plead?
No, ma'am. No.
Other than the plea agreement, has anyone promised you anything that caused you to plead?
No, ma'am.
You chose to plead of your own free will after you talked about everything with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of Mr. Perone? Have you been happy with the representation of Mr. Perone?
Yes, ma'am.
All right. Sir, did this offense occur on or about April 10th, 2025?
Yes, it did.
In the township of Allen, county of Ingham, state of Michigan?
Yes, ma'am.
You came in contact with law enforcement at a specific location known as Hagler Road in Allen Township at I-96?
Yes, ma'am.
And you were in a motor vehicle?
I was, yes, ma'am.
And did you have a firearm in that motor vehicle?
Yes, ma'am.
And that was without any special permission or authority to have it at that time in the way that you carried it?
That is correct, yes, ma'am.
On behalf of the people, any additional questions?
People are satisfied, Your Honor.
Mr. Perone, any additional questions?
Defense is satisfied, Your Honor.
Our counsel were promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Has court complied with the court rule?
You have, Your Honor.
It has, Your Honor.
May we go to sentencing?
Yes.
What is the recommendation of the people?
Your Honor, at this point in time, the people would recommend a gun safety course as well as costs and fines in this matter. Thank you.
I would go along with that recommendation. Part of the deviation from the general policy was this was a unique case. Mr. Hopkins was over the road trucker. He's from Texas. He's a Texas resident. The law is different there. He didn't know that he couldn't carry it in the manner he was in Michigan, but he should have taken the time to discover what the interstate laws were. So he acknowledges responsibility. I think it's a good recommendation to go forward with fines and costs.
Sir,
He's all,
anything you want me to know?
Was that for me, Your Honor?
Anything you want me to know?
No, ma'am. No, Your Honor.
So you're a trucker, you go through different states?
That is correct. At that point in time, I was a newly established business owner, and I was frequently OTR, meaning over the road. And like Mr. Perron said, I should have did more research. I was treated very, very great in Michigan by the suppliers, my delivery, and I really should have just read a little bit more about the states and areas I was going to be in.
Yeah, I mean, sir, it seems to me to be an honest mistake, but especially as a trucker and you cross borders, the laws vary about how you can drive, where you can drive, the speed limits, the gun laws, the drug laws, everything. And if you're going to do that, you need to be informed.
Yes, ma'am.
So I'm simply going to, as much as I would like you to have a weapons safety class, you don't live here, and I don't know. I don't know. I don't think you were being irresponsible. I think you were just being a little bit naive, opening a new business and doing what you were doing. So hopefully now this has been a wake-up call. So I'm going to assess the mandatory fines only, which is the $50 state cost and the $75 crime victims. That's $125. How much time do you need to send that money to us?
As soon as we're completed, I could have that sent.
Great. I'm going to give you until April 1st.
Okay.
All right. You have 42 days
Yes,
to
ma'am.
appeal and request appellate counsel. Counsel, please send him his appellate rights and then send us a proof of service and we're done.
sounds good. Thank
Good
you.
luck to you, sir. Thank you.
Thank you very much, Your Honor.
Any credit days?
Did he have any jail days, sir? Did you go to jail?
I did go to jail the day I was arrested, and I think I was able to PR bond out the next day or the following day.
All right, just give me 2 days of credit for 2 days. Not gonna make any difference. All right, thank you.
Yes,
Thank
ma'am.
you, Your Honor.
Next matter.
I'm not seeing any other attorneys.
What about,
I'll go find them.
her? What about that one?
He may have to go downstairs apparently and talk to him. But I can go tell him that you want to hear.
Oh, we want it now. He had all morning. And I thought you were entertaining.
No, you're not.
Do we know what we're doing next or not?
I don't know. I'm thinking it's this one, but I don't know.
Every time I think I have a case that's gonna be dull and normal, no, it changes on me.
She hopes it's Hank's next, is what we're.
Today though, I've just gotten initial pretrial comments, so it's just for me filled out.
Oh. So no entertaining phone calls today?
No,
Well, Attorney Starks talks to Javon Hanks. We're ready to go on Frank Moore.
Okay.
This may be a plea.
This motion in limine.
No, it's supposed to be a plea. Huh?
Frank Moore, the motion in limine is on Tyron Stuckey, yes.
The book that will be.
And that will actually not be a motion hearing, that'll be a plea as well.
Okay, so if we do it sooner than later.
Well,
That's what I was told. But not a motion.
So we already did this one, right?
Your Honor, may I approach with the plea agreement in the rights of rights form?
This is docket 256354FH, people of the state of Michigan versus Frank Willie Moore III. Counsel, your appearance for the record.
Good afternoon, Your Honor, APA Burbux on behalf of the people of the state of Michigan.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Moore, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
You put your hand down. Are you taking any medication yesterday or today?
No.
Are you supposed to get medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And you had enough time to speak with Mr. Goodrich?
Yes.
All right. Do you still reside on Saginaw Street when you're not in lockup?
430 North Lawrence.
The shelter.
Who lives there with you?
No one with me.
You, okay?
It's a shelter, Your Honor.
The shelter,
Yeah.
okay. So you're homeless, aside
Yes.
from that, all right. Are you able to work?
Yes,
What you do?
construction work.
Okay. Are you a US citizen?
Yes,
Count that you're pleading to, were you on parole, probation, or bond conditions at that time?
no,
On behalf of the people, what is the plea?
Yes, Your Honor. The defendant will be pleading to count one, retail fraud, first degree. Upon successful plea and sentencing, the habitual offender status in its entirety will be dismissed. In addition, Your Honor, there is an agreement, I believe, the agreement was to no upfront jail. However, the defendant would agree to inpatient treatment. I believe he is already, so he does have a case in 55th District Court, and as part of that case, he has been sentenced to go to inpatient treatment, but I'm just kind of wrapping that up in this case as well.
Inpatient treatment for alcohol, drugs,
alcohol.
alcohol? Okay. So my understanding, sir, would be once you plead, we can send you and then, it should be a long-term residential treatment.
Yes,
And then we can do the sentencing, they can zoom you in, would that be okay with you?
yes,
All right, then Mr. Goodrich could be on Zoom or here or however, there's all time to talk with him and go over pre-sentence investigation report before you come in on the record with me. Yeah,
will I be able to do the pre-sentencing while I'm in treatment?
yes,
Okay,
yes, I believe they'll Zoom with you there
all right,
unless they're able to do it before you go, but I suspect they'll work it out, they do it a lot.
okay.
Okay, all right. So that was full, fair, accurate, and complete
Yes, Your Honor.
So that was your understanding of the plea agreement?
Yes,
Okay, and, is there restitution in this?
No, Your Honor.
And so he's pleading to count one, here it is. And, are you waiving reading the habitual notice in its entirety?
Yes, we are, Your Honor.
Thank you. As to count one,
Yes, Your Honor. People of the state of Michigan versus Frank Willie Moore III, State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney appears before this court and informs the court that on the date and at the location described below, the defendant in count one, retail fraud first degree, on or about October 17, 2025, at 1982 West Grand River Avenue, Okemos, Michigan, 48864, Ingham County, State of Michigan. The defendant did, while Macy's was open to the public.
Wow, what to the public?
While Macy's was open to the public.
Macy's. Thank you.
Steal property of the store that was offered for a sale at the price of $1,000 or more, contrary to statute. Retail fraud, second or subsequent offense. It is further appearing that on 10/20 of 2009, said defendant previously convicted of violating 750.365D in the 55th District Court. Therefore, this violation of MCL 750.356D subsection 1 constitutes retail fraud in the first degree. This is a felony punishable up to a maximum of 5 years and or $10,000 or 3 times the value / difference in price of property stolen, obtained, or attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact at trial. See case law. Court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution.
Sir, did you understand what was just read?
yes,
So you understand count one, retail fraud first degree is a felony punishable by up to 5 years and or $10,000 or 3 times the value or difference in price of property stolen, obtained, or attempted to be obtained, whichever is greater.
yes,
And looks like you signed the advice of rights form. Did you read it before you signed it?
yes,
Did you understand what you read?
yes,
And if you had any questions, was Mr. Goodrich able to answer those in regard to your rights?
yes,
Do you have any questions about your rights of this court?
no,
Sir, as to count one, retail fraud first degree, how do you plead?
guilty,
Do you understand that by pleading guilty, you're giving up your presumption of innocence, your ability to cross-examine witnesses and evidence, your ability to choose to provide a defense, and also an automatic appeal if you didn't like what happened at trial? Now you would have to ask permission of the Court of Appeals to appeal.
yes,
All right. And sir, other than the plea agreement, has anyone told you what I will do at sentencing?
no,
And there's an agreement that you can go to treatment. It doesn't look like there's any other agreement aside from the restitution amount.
That's correct.
Or if there's any. So if you violate the law or bond conditions, or if I send you to treatment and you decide to walk out, some people do that, then things are not gonna go so well. Do you understand that?
I'm aware of that.
I will also say, Your Honor, that there was a Killer Bruno upfront jail at the time of sentencing.
Oh, okay, so then if you violated the law or bond conditions, is that correct? Now that makes it complete.
Yes, I think he stated that earlier, I guess. I missed that, you missed it.
Yeah, I didn't see that. Okay, we didn't get it on the record. Okay. So if you violate the law or bond conditions, then I could sentence you to some jail. However, if everything's going well, you do the right things, and I still send you to jail, I would allow you to withdraw the plea in this manner, would again go to the pretrial stage. Do you understand that?
Yes,
All right, very good. Sir, did this offense occur on or about October 17th, 2025,
yes,
in the township of Meridian, County of Hingham, State of Michigan?
yes,
And I'm sorry, you decided to plead after you spoke with, Mr. Goodrich, is that correct?
Yes,
And, I'm gonna, I kind of got ahead of myself a minute. Did I ask you, to plead yet to it, the count?
yes,
Plead guilty?
yes.
Okay, okay, thanks. I do it so often, sometimes I have to wonder if I did it or not. Anyways, and you pled of your own free will after you talked to Mr. Goodrich and you've been satisfied with his representation? All right,
Yes,
all right. And so, sir, did you, on October 17th, in the township of Meridian, County of Ingham, State of Michigan, enter, looks to me to be the mall, Meridian Mall,
yes,
and you went into the Macy's?
yes,
And did you take property or attempt to take property that did not belong to you?
yes,
Was it offered for sale at a price of $1,000 or more?
yes,
And were you stopped in the store, outside the store, or something else?
yes.
Would you?
Outside the store, yeah.
Okay, and what was the item or items that you took?
It was jewelry.
And you took that and you had no intention of paying for it?
Right.
Was it returned in a saleable condition?
Yes,
All right. And you were previously convicted in the 55th District Court for retail fraud, second or subsequent offense on or about October 20th, 2009, is that correct?
yes,
So this offense on October 17th, 2025, that's why you get this additional, because a retail fraud is normally a 93-day or a year
Right.
misdemeanor, but now it's enhanced because you've done it a couple of times. Okay. Additionally, it's because of the price, it was $1,000.
yes.
Okay, all right. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client, any additional questions?
No, Your Honor.
Our counsel or promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule?
You have, Your Honor.
Yes, you have, Your Honor.
I find defendants pleased when freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter as retail fraud first degree. The habitual third is dismissed in its entirety. And at this time, I'm going to send defendant to residential treatment concurrent with the sentence that he is serving now, which would include treatment for alcohol, so he's allowed to go. So I'm not gonna hold you back. So what will happen is whatever your bond is, as soon as you are accepted into the treatment, it's going to turn into a PR bond, so that you can go to treatment. The conditions, sir, is that you stay in, I want long-term residential treatment for the alcoholism, and that you comply with everything in the treatment facility, okay? You gotta wanna get better. We have
Yes,
people walking away, we have people making their own alcohol, we have people, you know, interfering with the testing. Don't do any of those things, okay?
I want,
Let's get your life back on track, okay?
yes,
Sounds like that's the deal everybody's making for your rehabilitation, so it takes you to take those steps, and it can be a hard journey. So if you have any issues, if you need something, you need to let us know. Don't take matters in your own hand, okay?
Right.
All right, what is the sentencing date?
April 29th at 10 a.m.
All right, so we'll figure out where you're at, and then we'll zoom you in. If for some reason the facility can't Zoom, sometimes Zoom doesn't work. Last week we had an issue where Zoom, we couldn't hear anything. So if that happens, we'll just move the sentencing to the time when you get out.
okay,
Okay, so stay in contact with Mr. Goodrich, okay?
all right.
All right. Anything else we need to make a record of?
No, Your Honor, thank you.
No, Your Honor, thank you.
Your Honor,
Yes.
you want his current sentence to be finished at treatment? Is that what you're saying? Does he have any current sentence?
He is a concurrent, well, what's happened, my understanding, the district court orders that he can go to treatment. So whatever time or whatever they're doing, I'm just making it all right together.
Correct. I agree.
So the files, I don't know what his other file is, the district court file. They will tell us.
Well, as long as he's going to treatment, I think it should be.
I think it's just fine to say the treatment are consistent with what the district court's doing. Does that work?
Yes.
I never know.
If he is.
I try to have verbatim what you say.
I know.
Sometimes I have to.
No, and I appreciate it. I read copies of these and you're like, oh, it's just like this. Okay. Yeah, no, I appreciate it. Right, what's next? It's always good to know that.
Hanks is on his way out.
So, yes,
Oh,
yes,
good.
and he can be released for treatment.
Okay.
So I don't have a problem on the record with that.
Is he,
Yes.
thank you.
Sure.
Who's on Hanks? Okay, cool.
Mr. Search, he's probably coming
Oh,
out.
he's probably coming back. Okay.
You should know who's on. You read all those.
I should, but you know,
I said.
it just says corn.
The love presents.
Yep.
What? Highlighters. You have to have green, right?
I just got my green one. This is docket 25516 FC, People of the State of Michigan versus Siobhan Hanks. Counsel, your appearances for the record.
Good afternoon, Nicole Matusco on behalf of people.
Good afternoon, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Hanks. He's present at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a motion to reduced bond, is that correct?
That's right, Jen.
That's correct, Your Honor.
Prior to this, sir, however, you seem like such a nice young man. I've read your history. It's not the worst, but you have few things that are not so nice as well. What is troubling to me, before we even get to this motion, is that I do not let anyone, and I mean anyone, disrespect a public defender, disrespect a prosecutor, law enforcement, or anyone in my office. I have a stack of letters that you have written to a prosecutor who does an outstanding job. I will read some of it to remind you of the disrespect that you have shown. Here's a letter that starts out, "Hey, bitch Matusko, it is Yvonne Hanks writing you again. This case has been going on for over 13 months now, and still not a plea deal been offered to me." It goes on. And then you say, "I do not know what the fuck you have going on, but you need to get this petty ass case figured the fuck out right now, right about now. What I did is wrong, but all I did was use a fake gun to take a breeze and a dab pen, a breeze, B-R-E-Z-E, and a dab pen from Amanda while I was high on multiple different drugs. This is not a hard case to solve, so why the fuck are you keeping me waiting, bitch? Prison is not the only option for this petty ass case. I understand consequences come with bad decisions I make, but bitch, I deserve to know my consequences. Bitch, let me know. So bitch, this is what you are about to do after reading this. Sit and think for 5 minutes about a reasonable plea deal for this petty ass case. Then tell Amanda about what you thought of, and then afterwards, you're going to tell my lawyer about the plea deal. The end." Here's another letter. "Hey, bitch Matusko, this is Yvonne Hanks, writing your bitch ass again. Still no motherfucking resolution. Huh, bitch? It is not hard for you to figure the fuck out what you want to do with me, bitch Matusko. This case is petty as fuck. This case is so fucking frivolous, okay? Yes, I know I did something wrong, but this is not some type of big case. This is not an average armed robbery. All I did was use a punk ass BB gun to take a punk ass dab pen and a punk ass breeze while I was high on multiple different drugs. Bitch, stop playing and give me rehab with probation. Do not even offer me any prison time because I am not taking it. So with that being said, bitch Matusko, I need some type of plea deal with no more upfront jail time immediately." Goes on to talk about other things, about the plea deal, and then said, "I did shit to people who did less than what you are doing. So fat funky bitch, hurry the fuck up. It is time we wrap this case up." And when you bring these letters up in court, mention my reason for them. Oh yeah, I do not give a fuck about you reading these letters in court. Go ahead, I want you to. No fucks is giving. Have a bad year, bitch Matusko. Oh, it doesn't stop there. "Hey, what's up, bitch? What the fuck is your problem, bitch? Your bitch ass still have not come up with an offer so we can end this damn case. This case is so fucking petty. I do not know why the fuck you have not dropped my charge down to unarmed robbery or larceny from the person I truly did learn my lesson. Nobody got assaulted. I was high on a few different drugs at the time of the incident. I only did that for a breeze and dab pen. I clearly have a drug problem. I have over a year of jail time served, I am open to accepting rehab and intense probation, bitch. Again, more vulgarity. And then, P.S. I don't care if you bring these letters up in court, bitch. Come with a plea, do your job, bitch. Oh, yes, there's another one. All right, look here, you little fat ass bitch. You continue to talk bad about me in court, including mentioning my old ass text messages that have nothing to do with this fucking case. You are worried about the wrong shit, but you still have not resolved this damn case that has been pending over a year. Not even one motherfucking plea been offered to me. What the fuck are you waiting on, bitch? Keeps on going. Yes, there's another letter. Bitch Matusko, this is Javon Hanks writing your whole ass again. You stupid bitch, it is time to wrap this petty ass case up. Slow ass bitch, stop taking your time. I am ready to get the fuck on with my life. Why the fuck are you keeping me waiting, hoe ass bitch? I deserve to know how much longer I am going to be locked up, pussy hoe. I do not give a fuck about you telling the judge about these letters. The fuck you can show her shit. You can read this shit in courtroom for all I care, or should give me all letters I wrote you, and I will read them in court with a big smile. I don't see you smiling now, sir. And I suggest you don't, because this isn't very funny. I am not scared of you, nor the rest of them crooked bitch-ass prosecutors that work at your office, including y'all master, John Dwayne. Oops, let me check myself. I mean, bitch Dwayne. Y'all can suck the cum out of my big black dick. Fuck every business building on Kalamazoo Street, along with the whole Michigan Avenue bitch you trying to send me to prison over a BB gun, breeze, and dab pen. The victim was not assaulted. That shit is not worth any prison time. And it goes on. You owe the prosecutor an apology. You will not write these letters. You do not have the right to assault verbally the prosecutor or your attorney or anyone in this courthouse. None of us are in handcuffs. You are. You need to check your attitude and think kindness. These words are fighting words. They're assaultive and very disrespectful. Let me remind you, these are not small charges. And I don't even have a police report, but I'm looking at these charges. Count 1, armed robbery is a felony punishable by life or any term of years. Count 2, weapons, dangerous weapon, carrying with unlawful intent, felony, 5 years or $2,500. Count 3, weapons, felony, firearm, pneumatic gun. I don't have what that, just apparently doesn't have what that is. Is that a 2-year?
Your Honor, it's a mandatory 2-year consecutive to the underlying offense.
That part's missing in here. But anyways, I thought it was a 2-year. It's a 2-year. Mandatory consecutive, you see. These are some pretty big charges. And it is only a small man who uses those words against a woman or against anyone. Those words do not make you strong, they make you weak. And it's very disappointing, sir. You have a mother?
Yes, I do.
You love your mother?
Yes.
How would you like it if somebody wrote those words to your mother?
I would not. I wouldn't like it.
Then what were you thinking?
I was angry. Case been at a standstill for a year and a half. I know it's not a good excuse, a good reason of why I did it, but I just been in a dark space mentally, just ready to get on with my life. I learned a big lesson since being locked up, just ready for a resolution.
Sir, I'm here every day. Law enforcement, even on vacation, will call me, the jail will call me 24/7. I'm not unknown. Your attorney in his office is not unknown, and neither is the prosecutor's office. If you had a problem, you tell the sheriff's gonna call us, one of us, all of us, and we're gonna help you. These letters hurt your case. If you think that I am going to entertain a bond after I read those angry words, those fighting words, the answer is no. So y'all can make your record, but when I look at this, I look at danger, I look at threats, a lot of anger. We're gonna get this resolved. I don't know what's going on here. I think we've had a few pre-trials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March, Your
I think
Honor.
it's March 11th, Your Honor, we have a final pretrial with a trial date in April.
So what is, shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening. Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. I'm going to be gone from the 27th through March 4th, Your Honor, but I will make every effort to make sure that Mr. Hanks is well informed of what his offer ultimately is. And then we will be ready to proceed on March 11th. And then if we have to proceed to trial at that point, then so be it, Your Honor. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusko, to try to see if we can find some common ground here to a resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial on that date if needed, Your Honor.
Ms. Matusko, are you asking for contempt?
Your Honor, this time I would be asking that bond be revoked. We are set at 250. I believe the court rule allows it. The court did not read into the record the final statement on the final letter that I did receive in January. And that was.
Which one is that?
I don't know if yours are in the same order, but it says, P.S. I did a lot of bad shit to people who did less than what you are doing to me right now. Bitch, you better be safe. That ain't no threat either. That's a direct threat to
That is a direct
the prosecutor here. It's not that we're using angry words. It is that we are literally threatening. And this has been Mr. Hanks' consistent MO whenever he doesn't get his way. So rather than asking the court for contempt, it is my intention when I make my record as to the conditions for pretrial release to ask this court to simply revoke bond. So there's no way he gets out prior to that trial date.
I don't know how I missed that. I was just so appalled reading all of it, but it is also in capital letters what you just read. P.S. I did a lot of bad shit to people who did less than what you're doing to me right now. Bitch, you better be safe. That's all capital letters. Capital letters means anger and is threatening. Under it, it says that ain't no threat either, meaning it's gonna be a real issue. Is how I read that. Like you're gonna make good on it, not a threat. Bond is revoked. Any more letters, bad behavior, every single letter, every single bad behavior will be in 93 days. Contempt. Consider this a huge warning. Sir, you can't treat people like that. I don't know what anger issues you got, We're gonna get you some treatment, mental health treatment in jail. Because if you continue this path, you're gonna be in prison. You're not doing yourself any favors, you're not keeping our community safe. Your anger's getting the best of you. You've been in front of me before, you've always been respectful. So I don't know what's hard, I am sure that it's very difficult being young and in jail. But you see, we have a retail fraud, height was revoked. You have defrauding an innkeeper. You have CSC fourth degree by force or coercion. We have, do we have a pending charge? We have 2 files.
Your Honor, the pending charge was when he was out on tether. He cut his tether and was found in possession of cocaine. So the pending charge is having cocaine in his pocket.
So you got drugs? And you've already acknowledged in here that you were high and not making the best decisions. So you gotta address these issues, and we're gonna have that happen in jail right now. Is there a final offer, or are you still working on that?
Your Honor, it's my intention to meet with the victim in this matter. We've been working around work schedules and my own personal schedule within the next week, so that I will convey that final offer to the public defender's office. I understand Mr. Sark will be out, so if you'd like me to put additional individuals on that email, once I can convey it, I can absolutely do that.
I will be monitoring my emails while I'm on vacation. I have to prepare for a trial anyway, so I will make sure that we get this information to Mr. Hicks. Thank you.
All right, and did you give me the date of the final pretrial?
I believe it's March 11th. I didn't write down the time.
Well, this has to be a final, I have a final pretrial this last September, so I don't know what happened, but I know there's been a lot of changes and other things that have happened, so.
Sure, I can address that.
Okay,
Previously, this case was being handled by Dale Caldwriter from my office, who was the assigned prosecutor in this case. Mr. Hanks made the decision to write him letters as well. So when I was covering this court, I took this case over to remove Mr. Caldwriter from the file to hopefully stop those letters from happening. Those are not attached to this motion, as I only wanted to update the court as to what has transpired since the last time this court denied bond. And it's clear that the letters were getting more threatening once they were directed towards me. So I took this case over in September. Mr. Sartz and I began negotiating, exchanging information, mitigating information, discovery, to see if we could get a resolution in this case. So that's why that final pre-trial was adjourned back in September.
all right, March 11th, final pretrial, you're here,
Yes, Your Honor.
and then when is the trial?
It's April 24th.
Your Honor, I am scheduled to start a trial on March 10th, but I believe that's going to be motion day on Wednesday. It's in front of Judge Stokes. So is the 11th a Tuesday or? I'll make sure we get this handled, Your Honor.
March 11th is
Wednesday.
Wednesday.
March 11th is Wednesday, so I should be, I will be here.
I'd like you both to look up backup dates, whether it's earlier or later than this April 24th date. We need to get this to trial, because I know that on April that week, I think we have probably 4 or 5 scheduled that we did. And I don't think that, I think a couple of them are older than this, so we need a couple backup dates unless you want to prioritize this because he's in lockup.
I will work with Mr. Buxton to see where we are on the list and then communicate that to Mr. Sartz as well. If a backup date is necessary, Mr. Sartz and I can work the schedule to get one.
You're remanded to the jail. You're gonna work with community mental health, see medical, psychological, go to CATS, get some treatment over there, sir. This cannot continue. I know you don't like jail. Or you gotta change what you're doing out in society, or you're gonna be in jail, and then you're gonna be in prison. And this has not made me happy to do this to you, but I don't know what else to do. We have public safety. And I'm fearful if I were to let you out again, it would get worse. So go into jail and work on what you need to work on. And there'll be no more letters like this. Otherwise, it's 93 days, every single letter. And that does not count against any other sentence. That is separate crime. Have I made myself clear?
Yes.
Do you have any questions about what I mean?
No, I understand.
Is there anything that you need over in the jail that you're not getting?
No, can't think of anything.
Quickest way to get out of jail is to behave. Start working on your rehabilitation. Talk to your attorney. Don't be rude, crude, angry. We didn't commit the crime. You're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at public safety. What I see here is not safe. You're entitled to your trial and you're gonna get one. But I also want you to consider these letters that you admitted bad behavior, criminal behavior. So I don't know how that's gonna play in, but you didn't do yourself any favors, sir. You said who you were, you wrote these, and you talked about what you did. Those statements can all come in at trial. If there's any pretrial notion about motions that this isn't gonna come in, set it in front of me, but I don't know how you get around this from coming in if people wanna bring it in. You can talk about that with your client, you need to talk about that with your attorney. Have I made myself clear, sir?
Yes, you have.
Very good. Is there anything else we need to address?
Yeah, Sharon, I believe we addressed it at the December court hearing. The no contact order with the victim in this case is Amanda Jean Smith. We also added Alyssa Hill. Alyssa Hill is either a witness or a co-defendant. I know Mr. Starks and I have worked to get her an attorney appointed because some of the letters implicate her as well. I just want the court to reaffirm that no contact order and make it clear to Mr. Hanks that that includes reaching out by way of a third party. He recently made phone calls to a third party to make contact to Alyssa Hill. That third party did cut him off, would not engage in much of a conversation, but I just want to make it clear that any contact, whether directly or indirectly with Ms. Hill, would violate this court order.
Do you understand the no contact order? And Ms. Hill was already added. I have a note here, Alyssa Hill, potential witness, and she may have some culpability. We need conflict counsel for her.
And
So
and she may have some culpability.
culpability, and we need conflict counsel for her. So I don't know if that's occurred. It should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with conflict counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you gonna have trouble not complying? Are you gonna have trouble complying, I should say?
No,
You understand no communication through third parties, so you can't call your friend and tell them to contact Alyssa or whoever? You can't call a third party and tell them to write a letter on your behalf? You understand what that means?
yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal. No Hallmark cards. No letters, phone calls, email, text. Contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record, thank you.
Thank you, Your Honor.
Ready to keep going next?
I hate to be the person next.
Right.
I mean, you know.
Well, no, not necessarily, because the next person, he just made you look real good.
True, true.
You can take those, it's gonna go one of two ways, either he made you look real good or just real mad.
This is gonna be
Sure.
a free trial.
It's, we were here last week.
I'm gonna do a plea.
You made a copy, no, he's gonna refuse on the record.
And what?
He's gonna refuse. You made a pseudo cobs.
Oh, yeah. Oh, yeah, okay.
But, yeah, thank you for the extra time. I really appreciate that. Sorry to walk out on the last hearing. It's a weird one to walk in on. Judges up here.
All right, this is docket 23-937 FH, People of the State of Michigan versus Keith Lauren. Counsel, your appearance.
Good afternoon, Your Honor. APA Barbucks on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Stephen Milks on behalf of Keith Lauren, who is present and standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you for doing that. This is a continued final pretrial. The offer was placed on the record last week, and counsel and defendant wanted some more time to think about it, so we gave you a week. And just so for this record, please remind us of the plea offer.
Yes, Your Honor. The plea offer was to an added count 3 of attempted felonious assault. Upon successful plea and sentencing, count 1 and count 2 would be dismissed. Count 1 being a felonious assault proper, and count 2 being a felony firearm, which has mandatory consecutive 24 months. We also gave a Killebrew to no upfront jail, and then Your Honor gave a Cobb's agreement to time served. After talking to the defense, it is my understanding that they will not be accepting that plea or that Cobb's agreement, and will be moving forward to trial on May 22nd.
Full, fair, accurate, and complete.
It is full, fair, accurate, and complete, Your Honor, if I may inquire of my client.
You may, but first, sir, have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no,
And you've had enough time to speak with your attorney?
yes.
You may inquire.
Thank you, Your Honor. Well, just as the court said, you and I did have a discussion over the past week just regarding this new plea offer. Is that right?
Yes.
And do you feel like I answered all your questions?
Yes.
And was I able to answer your questions?
Yes.
Is there anything else that you had questions asked, or did I satisfy any sort of?
You satisfied?
Okay. And it is my understanding that you wish to reject the plea offer and exercise your right to a trial.
Yes.
Thank you, Your Honor.
Did anyone force, threaten, or coerce you to make this decision?
No,
Did anyone promise you anything that caused you to make this decision?
no,
You made this decision to not accept the agreement or the offers by the court and counsel, correct, of your own free will?
yes,
And you did that after you consulted with counsel numerous times?
yes.
All right, then we will be moving to trial May 22nd. So sir, you'll need to work with your attorney, and we'll see you for trial then. Counsel, you'll make sure he's in a suit.
Well, and that's what we wanted to bring up, Your Honor, if I may, sorry.
Okay.
There seems to be an issue, one I've not really come across before, where my client has a PR bond, but he's still being held in jail. He doesn't have any other cases pending. There was a bond violation, I think, several months ago, but that was taken care of. He's served, I think, several days on that. It should be done and over with. When my office contacted the jail, they said that he was being held on either this case or the bond violation with a no bond. I'm not certain what's going on exactly. Don't entirely know how to remedy the situation, since it already looks on paper like he's got a PR.
So there was a bench warrant on December 1st, and bond was revoked, but then on December 9th, the bench warrant was recalled, and bond was continued and reinstated with GPS tether. So he should have been out. He should have been out December 9th, as far as I can see.
That's correct, Your Honor.
So he gets out. I've got the court note right here to make you a copy. The jail should have received this. I'm unclear what happened.
And that's just where I'm at too, Your Honor. I appreciate that very much.
Sir, where are you gonna be? Do you want to be released?
Yes,
It's cold out there. You're homeless. Where are you gonna be?
either the mission or a friend's house. I have friends that I can go spend the night at. I have places to go.
Okay, so each and every time you have a different address, you need to let us know, and you need
Yeah.
to work, you need to prepare for trial with Mr. Mills. And if
Yes.
you're not checking with pretrial services weekly and keeping us updated, I'm gonna have to do a bench warrant and put you back in lockup. You don't need to do that, sir.
I won't.
So are you able to work?
Yeah, I DoorDash. Well, I will actually look for a more stable job.
Do you have a car?
Yeah,
A car with no home? Where's the car parked?
at my friend's house.
Is that the friend you're gonna have pick you up?
Yes.
All right, sir, keep us informed, okay?
I will.
Thank you so much, Ron.
I terribly sorry we held you a couple months and cost the county a lot of money, whoever didn't read. Apparently, the court staff doesn't know how to read, the jail staff, I don't know what
It's
happened
the
here.
jail staff.
Yeah.
If that ever happens, you just type me or your attorney would be,
I can't type. I don't even have legal mail.
okay.
I'm trying to figure it out, Your Honor. It's just, it's something new that I've not come across before, and it seems to be an issue that shouldn't be an issue. But I'll inform the court when it comes up. I'll do an order or sit an order or something like that. I know Mrs. Buxton will be.
All right, well, the good news is the worst of the winter is all hopefully over, so at least you had 3 hots and a cot.
Real lot.
Yeah.
Do you want it with GPS tether still, or?
Let's,
I mean, I
No.
feel like if I make a new bond, then it'll for sure go.
That might.
sure.
Okay.
You want
It's supposed to be on the record.
You want, wait a minute, are we, no, just a minute. Deputies, 1 minute,
Sorry.
with,
On the record.
no, it's not, let me talk it out for a minute. So, was the last one with GPS tether? How's he gonna plug it in if he's homeless? Do we want GPS tether? I'm not gonna order GPS tether. We already kept him for 2.5 months longer than we should have. So I'm not, or almost 3 months longer. So I'm not gonna give you GPS tether. However, you don't show up, you don't do what you need to do, you're just gonna sit in jail. You won't get out again.
Yeah.
Okay?
You'll have an address.
I need address, phone. You need to keep in contact with the pretrial services and your attorney, okay? I'm just gonna take away the GPS tether.
Perfect.
He has been very good about keeping in contact with me when he was out, Your Honor, and pretrial services. So,
All right,
Thank you.
thanks.
Thank you, Your Honor.
Yeah,
Your bond.
just PR bond, release them. Pretrial, so report to pretrial services weekly.
You want a sheet?
Put in the courthouse.
Do you want a form for it? Do you want a form, an order, or do you want it acceptable?
It's gonna be on the court.
Yeah, that's as long if it's on the court now, just, yeah, as long as it's under resolved, it's great.
Sounds good.
I appreciate that.
Yeah.
So what else do we have?
We have a plea at 3.
Cameron's Rodriguez.
There's a whole group back there. What do you-
Cameron Rodriguez, it's set for a pretrial, but only bond wants to be addressed.
Okay, well, where is he?
He is in custody and we brought up.
Okay, down now.
Yes, that will be it.
Letter?
Rodriguez.
Rodriguez, oh, sorry.
Just Rodriguez?
Yeah.
Bring Rodriguez up, please.
I remember Jason Brown. Yes. Aside from the, those 3 interviews. Just 2 and kept 1, parts of 1.
Yeah.
Did they have any body cam with him? I don't think
I don't know
they
if
did.
being body cam.
I don't remember that,
They had the co-defendant testify in that trial.
but not body cam.
I don't think so.
I don't think so either. Full picture on my screen. So maybe Mars.
Oh, yeah.
Schedule something early. By the way, that guy who.
Yes.
Yeah, they did that to me.
Oh, okay. So you ready to go to trial on Friday? Well, we'll get a new date tomorrow.
Where, you ready to go?
We have space on
No.
Friday.
No,
Did you get assigned Mr. Thomas?
Yes, he just got checked, yes.
Thank you.
Apparently this morning, so he's not had any time to review the case.
Welcome, that's my fault.
Yeah, I know, I'm aware.
Corey found me out.
You did, quickly.
I'm gonna have to talk with him. Have a talk with him.
It's like on Wednesday.
Mhm.
And it's gonna warm up for Wednesday, right?
Yeah, warm up Wednesday.
Warm up for Wednesday.
What do you mean?
Right, did you get Aaron's email?
Yep, she's in a breakout room.
Perfect.
Warming up for Wednesday at 332 words a minute. And I still have over 99% accuracy.
Oh.
Well, I mean, it's not hard when all you do is have to type the F word 30 times.
Come try it, Brian. Let's see how many times you can tap your hands in a minute, and then we'll talk.
It's just the F word.
You know, then we get the mistakes of go to the grocery store. I'll never live that one down.
Let's go ahead. Go ahead and sign these. That you have, that we went over with last year's app. Go ahead and sign here. And here's the second time we received. Next schedule date's not until June. If we get something worked out, we'll do something faster than that. May I approach with the pre-trial form?
Yes. That's right.
It's not a plea.
Oh,
We're just addressing bond.
Oh, we're doing.
Just pre-trial, just.
Yeah.
Okay.
Jump the gun there.
Yep. Okay. This is docket 256718 FH, people of the state of Michigan versus Cameron Rodriguez. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Burbucks on behalf of the people of the state of Michigan.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Rodriguez, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury? You can say yes or no.
Yes, ma'am.
Thank you. Sir, have you taken any medication yesterday or today?
No.
Are you not on? Any sign of fever, COVID, or other illness? You need the other words that I.
No.
Okay, good. This is we're making a record for you, okay? And so the court reporter needs clear words that can be found in a dictionary, so I need you to speak up, okay? All right. And I understand you want to address bond counsel?
Yes, Your Honor.
All right.
Your Honor, Mr. Rodriguez is 18 years old as we stand here today. There was an allegation that, the allegations in this case are, there's 2 counts of essentially great bodily harm for a domestic type situation that occurred 6 days after Mr. Rodriguez turned 18. He was in high school at this time. He's been attending Sexton. It's my understanding that if he were to be released, he would be able to go back to Sexton. He gets special education classes there, gets a lot of assistance. He has some limitations. He's got his mother and his sister, and I believe one other family member is here today in support of him. He would be able to reside with his mother on Hosmer Street here in Lansing. He'd be willing to do tether if that made the court more comfortable, but we're just trying to ask the court to change the bond from the 30,000, 10% to a PR bond, some form of PR bond at this time, so that he could be back in high school, Your Honor. And also, as the court saw in the pretrial form, I think the parties are going to perhaps work towards some type of mental health court plea in this situation.
So the victim, does she go to the same school?
She's actually about 22.
Okay. Do they reside in the same neighborhood, or is there any contact, or any reason to have contact?
No.
On behalf of the people?
Yes, Your Honor, the people do agree that we are looking toward mental health court in this case. I will say, however, looking through the notes, I know the victim is very scared, very, very scared of the defendant after all of this. As I believe, it looks as if this incident ultimately resulted in her miscarriaging on her child, Your Honor. She's very scared and concerned of the defendant. I believe that bond is appropriate. However, if Your Honor does let him out, I would be requesting a GPS monitoring device to make sure that the victim knows exactly where Mr. Rodriguez is, and he does not violate any no contact order in this matter, Your Honor. Thank you.
So who's in your mother's house?
Me and my sibling, my sister that's here right now. Just my mom and then my dogs.
Okay. So you and Ms. Scott were in a dating relationship?
Yes, ma'am.
You don't have any children with her?
No.
All right, so I'm gonna give you a $25,000 PR bond. They'll report to free trial services bi-weekly. You can do that by telephone or however they direct you to. You will be placed on a jail GPS tether with the indigent grant. You will not be within 1,000 feet of Georgia Crystalia, Crystalia, and Georgia is spelled Georga. Scott. You'll not be within 1,000 feet of her work, school, or home. You end up at the same Myers, you just leave.
Mhm.
You know, the same Taco Bell, you go over to a different one. I don't care if you paid for your order. She walks in, you walk out. You don't make don't wiggle an ear, you don't give her the finger, you don't send her a Hallmark card, nothing. No contact means she doesn't exist in your world anymore. So you don't contact her by smoke signal, carrier pigeon, letters, phone calls, anything. No email,
Okay,
not through third parties.
okay.
You shall not use, possess, consume, purchase, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. You'll show all prescriptions for medication from a licensed medical physician to pretrial services within 24 hours and take any psychotropic medication as prescribed. You'll follow your doctor's orders or recommendations. You will PBT and/or drug test as requested by pretrial services, law enforcement, any court officer, or your mother. You shall not own, have in your possession, or under your control any weapon or gun, ammunition, imitation of a weapon, or be in the presence of anyone who has those items. You'll not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You'll maintain your current residence with your mother. Any change of address would be reported to pretrial services, the court, and counsel within 24 hours. You'll appear for all hearings and proceedings. What is our next court date?
It should be on that pretrial form, Your Honor. It looks as if it is a set for a final pretrial on June 24th. However, if we get any updates in the mental health court referral, then it may be sooner.
What is that at 1 o'clock?
That is at 9 o'clock. Oh, yes, that's at 1, Your Honor.
Okay. You'll attend high school regularly. All right, anything I missed?
No, you.
All right.
Oh, I guess one thing, did the court specify that the 1,000-foot exclusion zone was, if they can get in contact with the victim, because I believe she was homeless at the time of the incident.
Oh, okay, if,
They do.
so I just put, with victim notification if available, because we, I'm just gonna make a note, defendant or victim may have address or contact info, so they know.
Yeah.
All right, thank you, that's all.
Next court dates, okay.
Yes. Next.
We're gonna do Tyrant Stucky next.
Yes, you.
Okay, this is gonna be, and then are we done? Or what else?
There is at least one pre-trial that I do want to go on the record on because the defendant failed to appear.
Well, let's do which one that is, so I can mark.
Who's that?
That's Donald Audrin at 1 o'clock.
This is attorney here?
I'm covering for Mr. Lee this afternoon, Your Honor.
Oh, okay.
Right now.
Oh, yeah. It's the same words to the bottom of the first page.
Oh, no, the file.
Audrin, second from the bottom of the first page.
Okay.
Yeah, yes, I can. I just gotta.
All right, this is docket 256893 FH, people of the state of Michigan versus Donald Albert Odren, Odren. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP of Art Bucks on behalf of the people of the state of Michigan.
Sorry, Your Honor, I apologize. Attorney Aaron Schroeder, on behalf of Mr. Odren, filling in for his assigned counsel, Mr. John Lee. Mr. Odren has, I've called the hallway. I know Mr. Lee has attempted contact. We have not had contact. I don't know where he is.
We've not had any messages. We now about 7 minutes to 3. This was scheduled at 1 p.m. Bench warrant bond forfeiture for failure to appear for pretrial.
Thank you, Your Honor. And just for the record, Mr. Audrin has another file, 25-907-FH, that he failed to appear on January 29th on in front of you. So he is currently on bench warrant status on that case as well.
Now he's got it to 2:30.
Thank you.
Misdemeanor vice rights.
Yeah. Because we don't have, or can I cross out or just write on?
Yeah, it should be
Okay.
the same, right?
The same.
It should be the same. I thought so, but I wanted to ask before
Yeah, no,
I,
it's the same.
Here's the file. That's
they don't usually have these in court, so that's why I usually have one. All right, this is then advice of rights.
Yeah.
Do you have any questions? If you want to read it, let me take questions. I apologize, Your Honor. I was on Polycom with Mr. Bywater and I didn't get a chance to take care of this part
Do
earlier.
we need to go on the record with Mr. Bywater?
No, because he's muted, but he and I were using hand signals, so I'm
No,
gonna,
you got, let me know when I can unmute.
oh, it was on his, oh, well, whatever.
I mean, it probably was on his end.
It was on his end and he asked for somebody to come help him and they never came, so.
Oh, okay.
But he and I were able to communicate with me somewhat, so.
Was this our last one of the day then?
I believe so.
There are still 2 more pre-trials, Your Honor, it's set for 3. So obviously we don't need to go on the record if they show up, but I've not seen either attorney or defendant yet.
Well, what happened to dropping in Fortino?
Fortino, we took care of, Your Honor.
Yeah, that was the paper, that was a,
What was the other one you said?
Dropping?
Dropping, yes, we also took care of that pre-trial.
The Hopkins this morning. 9:30, Brian Jackson.
That was Perone, wasn't it?
Yeah,
Oh.
Brian Jackson hasn't shown up today.
Gotcha.
oh, he is in the hallway.
So then I can go look for him.
Hopkins was Perone, that they played.
Correct.
So we have Bywater, Jerry, King, now all those.
We did Jerry Gary
All
already.
right. Jerry, Gary, really?
Yeah, that was also by a pre-trial form.
No context. So one mystery.
The only ones we should have left is this case Stuckey, Bywater, King, and Schnell.
We did stuff.
We're doing it right now.
And then,
Yeah.
and then we need to talk about the paperwork for Bywater before we can submit that.
Is that, with those, are any of those gonna be pleased?
No, Your Honor, not at this time,
Okay.
with regard to Mr. Bywater anyway. So,
Oh, I might be this, I might.
As long as Mr. King and Mr. Snell show up today.
Yes, well,
There's somebody in the back there, I don't know which one it is, but he raised his hand.
Yeah. Okay.
Your Honor, if I may approach? And this is gonna be a no contest, Your Honor, for civil liability, so.
okay.
I've got the portions of the police report highlighted, and I've spoken with the prosecutor. And everything.
All right, thank you.
Yeah, he should be able to, because it's not being registered, right? Once the case is closed up, yes, and then a certain amount of time. Period, I think it's like 42 days, and then he should be able to get it back. It's gonna be kept, it's gonna be kept as evidence that we until the appellate period. Okay. I can look into getting something like that.
That's what I'm saying, because
Okay,
I
okay,
don't know how they.
okay, very good. I mean, we can do everything we need to do on our, I can't control it. You understand? Okay. No, I-
All right, this is docket 25-3159 FH and 25-3479 FH. People of the state of Michigan versus Tyrann's Lamar Stuckey. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stuckey. As to both files, Mr. Stuckey is present, stands to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, do you still live on Rio Road?
Yes, ma'am.
And who lives there with you?
No one.
And are you employed?
No, ma'am.
How do you support yourself?
I'm on disability.
Okay. And I understand there's going to be a plea today. Were you on bond, probation, or parole at the time of the offense?
No, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Taking any medication yesterday or today? Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
You had no time to speak with your attorney today?
Yes,
All right, I understand there's going to be a plea today?
yes,
All right, on behalf of the people, what is that?
Yes, Your Honor. It will be a global resolution in both files. In 25-3479-FH, the defendant will be pleading to an added count of aggravated domestic violence, that he will be pleading no contest. As a result of that plea, counts 1, count 2, and count 3 in that file will be dismissed upon successful plea and sentencing. And additionally, 25-3159-FH will be dismissed in its entirety. That is the witness intimidation as well as the habitual second offender status. There is also a Killebrew agreement to no upfront jail at the time of sentencing. However, the defendant does agree to a term of 12 months probation. And that is the extent of the plea offer, Your Honor. Oh, and the no contest is due to civil liability.
And the victim was consulted?
The Victims' Rights Act has been followed, Your Honor.
And so she's not here, or is she here? Can we go into immediate sentencing if she's here?
She is not here today, Your Honor.
Okay, so we'll set this. Okay.
The 12 months, Your Honor, I don't know, of probation, I don't recall that being on the plea sheet.
I thought we had discussed that previously.
So
Never mind, sorry, I apologize, it is a term of probation, Your Honor.
It is a what?
A term of probation. I apologize.
There's not a.
I was mixing it up with another case, I believe.
Okay, so there's no more than 12 months probation?
No,
Or
no,
probation?
it's just a term of probation, Your Honor.
Okay, a term of probation. Okay. Is that full, fair, accurate, and complete?
It is, Your Honor. I will note for the record that there was a firearm involved in this. My client just wanted me to make a record of this, that it is not registered to him. It was registered properly to somebody else, and it's currently in the police custody. I've indicated to him that his friend would have to go after the appellate period passes for this matter and try to regain possession of that, but it is not registered to him, so it would not be coming back to him.
It's forfeited, any weapons or contraband would be forfeited as to you, but the rightful owner could go get it upon proof that they're compliant with the law.
I understand that. I was just wanting something saying that this case was done, so he can go back and retrieve it. I know I can't go get it.
Yeah. Okay.
Thank you. Nothing.
So that was full, fair, accurate, and complete, sir, what was just stated?
Yes, ma'am.
All right, counsel, you're waiving reading counts 1, 2, and 3 on docket 25-3479 FH, as well as the habitual offender second offense notice, and count 1 on docket 25-3159 FH.
Yes, Your Honor.
as to count for the remaining count of the aggravated domestic violence and misdemeanor?
Yes, Your Honor. People of the state of Michigan versus Tyrants Lamar Stuckey, State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described, the defendant in added count 4 aggravated domestic violence on or about March 12, 2025 at 1326 Rio Road, Lansing, Michigan, 48910, Ingham County, State of Michigan. The defendant did assault Kara Ann Gonzalez without a weapon and inflicted serious injury or aggravated injury upon Kara Ann Gonzalez, but without intending to commit murder or to inflict great bodily harm less than murder, contrary to statute. This is a misdemeanor that is punished by up to a maximum of 1 year and or $1,000. If the assault was committed in a place of confinement, the court may order the sentence for this offense to run consecutive to any sentence the defendant was serving or the sentence for the offense for which the defendant was being detained. See statute. And against the peace and dignity of the state of Michigan.
This was, I'm sorry, 1 year, right?
It's a 1 year, yes, Your Honor.
All right, sir, did you understand what was just read?
Yes, ma'am.
So you understand aggravated domestic violence is punishable by 1 year?
Yes, ma'am.
And also you would pay, it's up to a year, but you would also pay restitution for any personal or property damage, if any?
Yes, ma'am.
And we already talked about as to the dismissed counts on this file and the other, any weapons or contraband are forfeited now, and only the rightful owner can go and get that firearm. You understand all of that?
Yes, ma'am.
All right, thank you. It looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes, ma'am.
And if you had any questions, your attorney was able to answer those in regard to your rights?
Yes, ma'am.
Do you have any questions about your rights of this court?
No, ma'am.
Sir, as to count 4 on docket 253479 FH aggravated domestic violence, how do you plead?
Guilty. No contest.
And that no contest would be based on civil liability?
Yes, ma'am.
And you understand the impact of the no contest plea? It would act like a guilty plea, but it's no contest based on the civil liability, so that this case cannot be used against you in another case.
Yes, ma'am.
All right, very good. Now, during this time, did you use alcohol or drugs?
No, ma'am.
Okay, so you recall the incident?
Yes, ma'am.
All right, you've talked about all of that with your attorney?
Yes, ma'am.
And you understand that you're giving up certain rights and defenses you would have had you had a bench trial or jury trial?
Yes, ma'am.
That includes a presumption of innocence and the automatic right of appeal if you were unhappy. So now, if you want to appeal anything, you should first have to ask permission of the Court of Appeals, and they'll only take up your case if they think your issues are important. Do you understand that?
Yes, ma'am.
And you decided to plead no contest after you spoke with your attorney?
Yes, ma'am.
And you pled no contest of your own free will?
Yes, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
Has anyone told you what I will do at sentencing other than the agreement for some kind of probation?
No.
And that's because I don't know. I'll make up my mind what happens at the time of sentencing. However, there was, part of the agreement was for no further upfront jail, I believe. And so if I gave you upfront jail, because I still could do that, I'm not part of the agreement, I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes, ma'am.
All right. However, if you violate the law or bond conditions, I don't have to allow you to withdraw your plea, and I could send you to jail. You understand that?
Yes,
All right. By stipulation of counsel, I have been provided Lansing Police Department case report 2551-902-360. It appears that this event occurred on March 12th, 2025 at approximately 1100 hours at a specific location known as 1326 Rio Road in the city of Lansing County, Ingham, state of Michigan. And it does appear that Kara Ann Gonzalez and Tyrants Lamar Stuckey, defendant in this matter, had a dating relationship and were residing together, and they had been residing together approximately 20 years and have 3 children in common.
Your Honor, I apologize. Mr. Stuckey, it's not, it didn't, okay. It appears that maybe the 17th, I'm the one who did the highlighting, I apologize, but I believe that was the date of the report potentially. As I'm looking at the felony complaint, it indicates that he's telling me here, March 12th was actually the date of the
What did I
offense.
say?
Then what,
It happened on the 17th. The police came to my house.
Okay.
On the 20th.
okay, so
I was
he's
in
indicating
jail.
it's on the
My first
17th,
day
the
in jail
20th,
was the
okay,
21st.
okay.
Well, so what you're telling me is, no. Sir, the witness bribing intimidation, that was on the 17th.
The first day I got put in jail.
Yes, but you're pleading to the other file, you're pleading to no contest to aggravated domestic violence, and that occurred on March 12th, it appears.
It happened 3 days before I came to jail, ma'am. That's what I've been saying all along from the
Okay.
beginning. The incident happened 3 days
Okay.
later. They came and arrested me. They arrested me on a Monday morning.
Okay, we can amend the date, I know.
The people can stipulate to March 14th, Your Honor, as that's 3 days before the March 17th date of the jail.
That's fine.
Okay, thank you, Your Honor, thank you. I appreciate that. I apologize to you, Mr. Stuckey.
Yeah, that's fine, because actually it says it was printed, that the officer printed this on March 14th. So we'll just amend the date to the 14th.
Okay. I apologize for my
I will do
oversight.
that as an amendment.
It's not your oversight, it's on the felony information, this is gonna have to be amended.
I have to amend it for the additional count anyway, Your Honor, so I will
Alright.
put that with you. I'll put the new date in.
Okay. All right. So where was I? They have 3 children together in a 20-year relationship, and it appears that Kara advised law enforcement that Tyrance was acting off all day and had not gone to bed. She said he stayed
Was acting
off
all day and what?
and had not gone to bed.
Okay.
She said he stated there was powder all over and she did not see it.
Yeah.
She said Tyrance gets really mad if you do not agree with what he is saying. She said Tyrance asked her what she had been doing to his clothes and told her he was itching. She said due to Tyrance being up for days and itching, she believed he had to be using drugs. And she said that she told Tyrance she saw nothing on his skin, and then it turned into a fight. And she said Tyrance got dressed up and she thought that was good because he would be leaving for the night. She said he locked the bedroom door and told her not to go in there. She said the bedroom is their shared bedroom. She said Tyrance also locked the basement and locks everything and she cannot do laundry. Kara advised she was like, whatever. And Tyrance came back at her, you think that's funny, bitch? And Kara mimicked removing a gun from her waistband and holding it, and then he went like this, she said. You can hear me screaming like, I'm like, no, it's not funny, it's not funny. She indicated Tyrance left the residence and returned around midnight. She advised that this morning it all started again. Where's the fight here? This is an argument. Did I miss something?
It would be the factual basis for the original felony charge of the assault with a dangerous weapon is what we'd be using.
Okay.
I should have been
So
clear.
stipulated?
Correct, Your Honor.
Okay.
So stipulated.
Okay, thanks. Obviously, I don't know this case like you guys do, so I'm looking at this going, wait. So I appreciate clearing that up. All right. Do either one of you want anything further read from the report?
No, people are satisfied, Your Honor.
As are the defense, thank you.
Thank you. Our counsel or promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
This court provided the court rule.
It has, Your Honor.
Thank you. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, duress, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 4 will enter on docket 25-3479 FH. It will be an amended information. The date will be changed. Counts 1, 2, and 3 are hereby dismissed. And count 4 will enter. Additionally, Docket 25-3159 FH is dismissed in its entirety. And any weapons contraband hereby forfeited, however, any owner can, rightful owner can pick that up. And any outstanding warrants on both files are hereby recalled and dismissed, if any. Do we have a sentencing date?
April 29th at 10:30.
Does that meet your schedule?
It does, Your Honor, thank you.
All right, sir, today, please go downstairs and make an appointment with probation. You can also call, you have 24 hours to call, but it's a lot easier once you're in the building, just hop down there, make an appointment, keep that. Oh, well, actually, we don't need that. I'm sorry, this is a misdemeanor, right?
Correct. Yes.
Correct.
We don't even need to wait till April 29th, do we? Although it's,
I mean, we just need to get the, I believe,
I mean, we can, it doesn't matter.
we just would need to notify the victim at this point and see if she wants to come or not.
Correct.
Do we have any time? Because I don't need a pre-sentence investigation report, so you don't have to do that stuff.
The soonest sentencing I have is the 29th.
All right, let's just keep it the 29. Sir, do you have a drug problem?
No, ma'am.
You have an anger problem?
No, ma'am. See, I mean, if I could speak freely,
Well, you just pled, now you can speak freely.
yeah, I played already, but all of this is going on, what she said. I never was questioned about anything that went on. This all went on what she said. And if anyone would have asked me my side of the story, I could have explained everything that was said.
Okay, well, just remember you pled no contest, but
I
looks like
understand that.
there's, okay, there was some stuff going on. Let me ask you this, are you and she still together?
No, ma'am, no,
Is your relationship over?
it's done, Your Honor.
Okay, I got it. Before I took the bench, I handled divorces for 20 years. I get it, okay? I get it. When it's over, it's over. What
Yes,
about, you got 3 kids together. How old are they?
we have 4 kids. The
4
oldest is 20, 15, and 13-year-old twins finna be 14 in March.
Yeah, I got twins too. They're a handful.
Definitely.
Yeah, I always, every year I hoped it would get better, but it doesn't. They're just a handful no matter what. But anyways, sir, are you seeing those twins?
Yes.
And you're seeing all your kids? So
Yes.
how is that happening? Because you're not supposed to have contact with her. How is
Their
that happening?
auntie, their auntie.
Their auntie
Yes,
is being,
ma'am.
okay.
When you let me out of
Did I
jail,
do that?
you said
Okay.
that
And
auntie.
that's been working good?
Yes, ma'am.
Okay, so we're all good on that front?
Yes, ma'am.
All right. So,
Also, she spoke on my behalf for me to get out of jail.
That is true, Your Honor. She came at the bond hearing.
She did.
so. Why don't you, counsel, find a domestic violence class or anger management class so we can shorten up his probation?
Yes, Your Honor, I will look into that, I think.
Or he can wait till April, but then I get to babysit him all summer. I don't think he wants that.
Do
Do
you
that
have
in jail?
Do you have any certificates? I'm trying to remember. I might be able to have my social worker reach
Great.
out to the jail and see if we got.
Great.
Yes, I will look into that. Okay.
Great, okay.
All right, so. And then, so the 29th, then he does not have to go down to probation. is that-
No.
All right, very good. These are your copies of everything, and then I will be in touch once I know if we can. Those copies of those certificates. And if you.
All right, well, just let me know what else I have to do.
All right, all right.
Thank you, Your Honor. Have a nice
Thank
day.
you.
Thank you, Your Honor.
Anybody else?
I believe that is it, Your Honor.
Weird awesome. Somebody next time.
We need to get the
Dismissed at 3.